USCIS requested an I-601 waiver, but your client has no qualifying relative, and you're certain the inadmissibility ground doesn't even apply. This is becoming disturbingly common with USCIS. I know your instinct is to fight and argue your client doesn't need the waiver. Definitely do that. But doing that alone costs your client a better strategy. Let me explain why. If you refuse to file the I-601 because your client has no qualifying relative, and the field office denies the I-485, you have no appeal rights. None. The regulations explicitly state there's no administrative appeal from an I-485 denial. Your only option without filing the I-601? Hope for an NTA and renew and removal proceedings where the IJ may agree with the field office that your client needs the waiver and isn't eligible. But file that I-601, even knowing it'll be denied because your client has no qualifying relative. Under 8 CFR 103.3, you can appeal an I-601 denial to the Administrative Appeals Office. The AAO has jurisdiction over denial waivers. That's your forum. In that appeal, you argue the waiver wasn't required in the first place because your client isn't inadmissible. The AAO regularly reviews first whether the inadmissibility grounds were properly applied before moving to the merits of the waiver. The AAO's own decisions confirm they examine threshold eligibility issues. They don't just rubber stamp USCIS's inadmissibility findings. You're essentially getting appellate review of the underlying I-485 eligibility determination through the back door. Now that appeal can remain pending even if your client gets placed into removal proceedings. Unlike the I-485, which dies upon denial, your I-601 appeal survives removal proceedings. If the AAO says no I-601 was needed, and OPLA argues that it is needed, present that decision to the immigration judge and OPLA attorney. Argue that OPLA's client, USCIS, already conceded through the AAO that no waiver is necessary. Then seek dismissal of removal proceedings for USCIS to reopen and re-adjudicate the I-485. Hold OPLA's feet to the fire that its client should be given an opportunity to correct its own admitted error. Think about it strategically. With these lesser-trained judges, would you rather argue de novo in immigration court that USCIS was wrong, or walk in with an AAO decision saying the inadmissibility ground never applied? Then you could seek termination to reopen the I-485 with USCIS. Now document this strategy in writing to your client. Explain you're filing a waiver you believe is unnecessary specifically to preserve appeal rights in an AAO determination of inadmissibility. Because if you don't file the waiver and appeal, and your client is placed in removal proceedings, explaining why you didn't preserve the AAO avenue when you could have, that could be malpractice. After Patel v. Garland, federal court review of discretionary decisions is severely limited, but the AAO, they still review legal errors, including misapplication of inadmissibility grounds. That makes the I-601 an appeal strategy a second option you don't want to throw away.